breach of somebody's legal rights. You should know the difference what is legal wrong and what is moral wrong. Suppose a person doesn't pay respect to his parents. It may be a moral wrong, but one cannot compel. The parents cannot compel the child to give respect to him. But suppose the parents has a legal right to get maintenance when they are unable to maintain during their old days from their children. So that is a legal right. So when somebody's legal right is violated in fees, we say that is a wrong in the eye of law. So to constitute a tort, to offer a tort, that is, there must be a civil wrong, that is civil injury, or otherwise tort or civil injury. There must be a wrongful act or omission. There must be a wrongful act or omission committed by a person. Second, the wrongful act must give rise to legal damage or actual damage. That wrongful act must give rise to a legal damage. And the wrongful act must be of such a nature as to give rise to legal remedy. These three things are there. There must be a wrongful act or omission by a person, and that wrongful act or omission give rise or causes legal damage or actual damage to a person, and that act must be of such a nature that is legally enforceable in a civil action. So that is a tort. That is, in other words, for a tort, there must be a breach of somebody's legal right. That is private right. So, in every tort, first we should examine, there are two maxims. That is, injurious sine damnum and damnum sine injuria. Injuria doesn't mean injury, no. Injuria means breach of legal right. Sine, without, sine means without, damnum means damage. Whenever there is a breach of a legal right, breach of trust is something that is not a tort. That is enforceable in other law, but it's tortious liability because unliquidated damages cannot be claimed. So here, other than breach of contract or breach of trust. So here, in every tort, we say there is my breach of, there must be a legal wrong. Unless there is a legal wrong, wrong means that is injuria. Then there will be no tort. So what is injuria sine damnum? There may be injury when there is a, and again you have to remember another principle, which is just ibu remedium. Where there is a right, legal right, there is a remedy. In this context, we will also discuss. Sometimes we get a question in the judicial service examination, what is the difference between law of tort and laws of law of torts? That is, in this context, Winfield, this says every action when there is a breach of legal right, that is enforceable in law of tort. But Salmon says, though breach of legal right, if it is not coming with any of the provisions, any of the rules for which there is a remedy, then that is not to be treated as a tort. So that we will discuss in this question, we will take in another session. But here, injuria sine damnum. There must be injuria here means breach of, there is a legal wrong, breach of legal right of somebody. Sine, there may not be damage, sine without damage, there may not be damage. Damnum means damage, there may not be damage. But when somebody's legal right is breached, violated, then an action lies under the tort, and one can claim damages under the law of tort. The act complained of should under the circumstances be legally wrongful. So the act which is complained of for getting damages in a law under the law of tort, that must be legally wrongful to the party who is complaining it. And thereby, in other words, he was prejudicially affected by that law. So an act which prima facie appears to be innocent may become tortious if that invades the legal right of somebody. So here, suppose if one erects on his own land anything which obstructs the light to a neighbor's house, it is no doubt lawful to erect a wall, and thereby light is over. But if that light is the neighbor is getting light for that is for an uninterrupted period of 20 years and above, and has shown unobstructed transmission of the light, then he may claim, he may file a suit for injunction. But here, the Aspi versus White case, the leading case Aspi versus White, you should always remember when there is the principle of injurious sine damnum. In this Aspi versus White case, what happened? That here, in this case, a voter, he went to cast his vote, but he was not allowed to vote, though his name was there in the voter list. The person to whom you would have voted, he won the election. And in spite of there was no damage to him. But when he filed a suit claiming damages for breach of his legal right, there he succeeded in the suit, and in the House of Lords, he was allowed to enforce to get some damages. So this is the leading place is Aspi versus White. So that is the infringement of somebody's private right. What are the private rights? Every human being has right for his body, mind, and property. What is this? Because body, right of reputation, that is a right of reputation, right of body, and safety, freedom, and right to property. So the reputation is called, that is mind. That right to body, mind, and property. So there must be a breach of somebody's private right. Question may come, why for breach of a public right one cannot claim compensation not be taught? Because the public right, if compensation will be allowed, then number of cases, there will be innumerable cases claiming damages for that. So that's a public wrong. When there is a breach of public right, that is wrong in rem, that is the crime. That is punishment is prescribed for that. Damnum means, what is damage? Damage means the harm or loss suffered. Damnum, that is, damage means the harm or loss suffered, that is by the person, by the act of the wrongdoer. The sum of money which is paid by the court is called damages. That compensation, the damage. Compensation, the damnum is damage. The sum of money which is paid as compensation to the damage, we say that is damages. So the difference, you should know the difference what is damage and what is damages. Damage means the harm which is caused. The money compensation which is paid, which is the court allows, court passes a decree, that is called damages. So here, that is this Aspi versus White case, damnum is make damage in the substantial sense of money. But when money compensation is paid, that is called damages. So this is the leading case in this case, that is refusal to register vote. This is Aspi versus White case. In the leading case, Aspi versus White, the defendant, a returning officer, wrongfully refused to register a duly tendered vote of the plaintiff. Duly tendered vote of the plaintiff was tendered, but that was not registered. A legally qualified voter at a parliamentary election, and the candidate for whom the vote was tendered was elected. The candidate in this, for which that vote he had tendered, that was not registered, and no loss was suffered by the rejection of the vote. So in this case, the returning officer had acted maliciously. So here it was held that an action lay on account of infringement of legal right of the voter because the returning officer acted maliciously. Where therefore a returning officer without any malice or any improper motive in exercising his judgment honestly refused to receive the vote of a person entitled to vote at an election, it was held that no action lies. Innocently, suppose he refused, that is no action lies. But here the returning officer maliciously acted. If a person entitled to be included in the electoral roll is wrongfully omitted from such roll, suppose somebody's name was, that is, accidentally that was omitted from the election roll so as to be deprived of his right to vote, he suffers a legal harm for which an action lies also. So here, an action for damages will also lie if a citizen is deprived of the right to vote by a law which is unconstitutional by reason of offending his right to equality. So this is similarly banker refusing to that customer check. That is an action lies injurious sine damnum principle. There may not be actual damage, but still the action lies under the law of tort. So here, this is injurious sine damnum. When the injurious sine damnum principle comes, you should always remember the leading case, that is Asprey versus White case. But in other words, damnum sine injuria. We find a damnum sine, there may be damage, but there is no breach of legal rights. That is not legal wrong. So suppose this, when various case laws are there, that is, in this case, in this context, we find number of cases, damage caused by lawful working of mind. Suppose where a landowner by working his mind causes that in the consequence of which the rainfall was collected and passed by gravitation and percolation into the adjacent lower coal mine. It was held that the owner of the latter could sustain no action because the right to work in a mine was a rightful property. So here, setting up a rival school. This is another example, that is setting up a rival school, that is Queen versus Latham. So in this case, where a landowner, that is where the defendant, a schoolmaster, set up a rival school, Glasgow Grammar School case. It is next to the door of the plaintiff and boys from the plaintiff school flocked to the defendants. It was held that no action could be maintained, compensation in no ground, driving rival trade out of market. A, B, C and D, ship owner who shipped tea from one part of another combined together to keep the entire trade in their hand, and they thereby consequent to drive F, another trader, ship owner out of trade by offering special terms to the customer who deal with them to the exclusion of F, A and B, C for the loss. So that is, it is when there is a damnum sine, it is there is damage but no violation of, no infringement of legal right. In case of damnum sine injuria, there is not a tort, no action lies. There may be damage, there may be loss, but when legal right of somebody is not violated, it is not a tort. But in every tort, there must be a breach of legal right, violation of somebody's legal right. So in another case, use of title by spouse after dissolution of marriage. It is also a very leading case. When the marriage of a commoner with a peer had been dissolved by a decree at the instance of the wife, and she afterwards, on marrying a commoner, continued to use the title she had acquired by her first marriage, it was that she did not thereby, though having no legal right to the user, commit a such legal wrong. That is against her former husband. Similarly, using another man's house, the plaintiff house was called Asford Loss for 6 years, and the adjoining house belonging to the defendant was called Asford Villa for 40 years. The defendant altered the name of his house to that of the plaintiff's house. The plaintiffs alleged that this act of defendant had caused great inconvenience and annoyance, and had materially diminished the value of their property. It was held that defendant no doubt violated legal right of the plaintiff, because here the damnum sine injuria. So, obstruction of view of suppose if this is also a damnum sine injuria case. Here the defendant, that is the plaintiff, carried a business in his shop, but the defendant put a board so that the view of the plaintiff's shop was obstructed. There no legal wrong was committed. Misdelivery of telegram, that is water supply cut off. Also, this is damnum sine injuria. So here, this Indian case you should also find. So in causing, ceasing to offer food to idol, a priest was offering, that is where the servant of a Hindu temple had a right to get the food offered to the idol. In this case, the servant of a Hindu temple had right to get some the food which is offered in a temple. But the person who was under an obligation to the idol to offer food did not do so. The person who was under the obligation to offer food to idol did not offer food. Thereby the servant was deprived of, servant was unable to get food, and the servant brought a suit against him for damages. It was like that. The defendant was under no legal obligation to supply food to the temple servant. There was no legal obligation. And though his omission to supply food to the idol might involve a loss to the plaintiff. Another interesting case is, that is loss of one academic year. What is case? A student was wrongfully detained for shortage of attendance by the principal on a misconstruction of the relevant regulation. They did not interpret the regulation correctly and wrongfully detained because of shortage of attendance. The principal detained that student. Thereby the student suffered the loss of 1 year. In a suit for damages, it was held that the suit was not maintainable as the misconstruction of regulation did not amount to tort. Misconstruction, this misapplication of the regulation, that is not understanding the regulation by the principal. Thereby he did not violate or infringe the legal right of the student. So that in the result for the two maxioms, that is injurious sine damnum and damnum sine injuria, there are moral wrong for which the law gives no legal remedy. It may be a moral wrong, but the law doesn't give any remedy, though they cause great loss. Though by a moral wrong, substantially loss is caused, still it is not enforceable under the law of tort. On the other hand, there are legal wrongs for which the law does give a legal remedy, though there may be only violation of a private right without actual loss, without damage, without actual loss. When somebody's legal right is violated, that is an action under the tort is maintainable. What is violated is a qualified right and distinguished from an absolute right. So here, damage is called variously expressed loss, particular damage in fact, that will discuss how many types of damages will be awarded in tort. So a tort right to support, there are various cases in which there may be loss, but still action will not lie under the law of tort. A tort is a civil injury, but all civil injuries are not torts. The wrongful act must come under the category of wrong, for which the remedy is civil action for damages. The essential remedy for a tort is an action for damage. But there are other remedies also, that is injunction under the law of tort. Other remedies also under the civil remedy, that is injunction may be obtained in addition to damages in certain cases. Restitution of chattel may be claimed in an action for detention of a chattel. So similarly, dispossession of land, recovery possession may be claimed in a civil remedy, but it is principally the right to damage that brings such wrongful act within the category of tort. When damage is claimed, and damage is claimed for a wrong, that is under the law of tort. There also exists a large number of unauthorized acts for which only a criminal prosecution can be instituted. Further, damage claimable in a tort action are unliquidated damages. Then the damages which is claimed, that is unliquidated. That is to be determined by the court. For example, as earlier seen, an action for money had been received in the context of quasi contract, where liquidated damages are claimed is not a tort action. So the law of tort is said to be developed in the maxim ibu jus ibu remedium. That is, there is no wrong without a remedy. Ubi jus ubi remedium. That means there is no wrong without remedy. In other words, where there is a right, there is a legal right, there is a remedy. Just signifies here the legal authority. Just means if you just legal authority to do or to demand something. And remedium may be defined as that right of action. Remedium means right of action or the means given by law for the recovery of assertion of right. If a man has a right, he must necessarily to vindicate and maintain it and a remedy. If he is injured in the exercise or enjoyment of it, and indeed it is a vain thing to imagine a right without a remedy. There cannot be you cannot imagine a right without a remedy. So that the maxim does not mean, as it is sometimes supposed, that there is a legal remedy for every moral or political wrong. So there is no legal remedy for the breach of a solemn promise. Somebody has promised, no remedy is there, not even sealed and made without consideration. So that's why. So this remedy is there. Always when there is a breach of legal right, that is remedy. Again, that is the breach of legal right. So this cube prevailing in the subject of existence of broad on the principle of tortious liability. Tortious liability. Tortious liability what is? The two views are set out in the question that Salmon asked. Does the law of tort consist of a fundamental general principle that is wrongful to cause harm to other person? So, there we will know what is tortious liability. That is, if under the law, that is, does the law of tort consist of a fundamental general principle that it is wrongful to cause harm to other person in the absence of specific ground for justification or excuse? Or does it consider a number of specific rules prohibiting certain kind of harm? Salmon preferred the second alternative, and his book for his reason is still entitled Law of Torts and not Law of Torts. So Salmon says Law of Torts, certain rules, certain remedies. So that is, Salmon preferred the second alternative. That is, in his book for his reason is still entitled as a Law of Torts. Winfield, on the other hand, accepted the second alternative, that is a narrow view only from the practical point of view as a day-to-day matter, but he contended that from a broader outlook, there was validity in the theory of fundamental general principle of liability. So law of tort means every injury which is, there is a legal right, breach of legal right, that is a tort. That is law of tort. Law of torts, that is taught by this, that is the that is the principle, that is Salmon's case. Unless a particular injury falls under a particular remedy, if a remedy is not there, that will not be treated as a tort. The entire history of the development of the law of tort, the tort law, shows a continuous tendency. So that is, the entire history of the development of tort law shows a continuous tendency which is naturally not uniform in all common law. So that is, generally the judicial process leading to recognition of new tort situation is slow and concealed. But in India also, this Salmon view is not accepted that unless there is a remedy, that cannot be a tort. That principle was not accepted. That India, that is Winfield's view, that every injury, legal injury, breach of somebody's, when there is a breach of that is legal wrong, that is somebody's right, that is a tort. Normally a new principle in judiciary accepted to accommodate new idea of social welfare, of public policy. Only after they have gained their recognition in the society, for example, in extrajudicial writings. So this is in nutshell we discuss this injurious sine damnum and damnum sine injuria. On the other day, we'll take a class what is the difference between law of tort and law of torts. Thank you.